So hi everyone again. So we are beginning up with our keynote session, that is alternative resolution of cross-border intellectual property disputes, which would be presented by Mr. Amit Yehoshua, international attorney, mediator and arbitrator, Amit and Company International Law Firm. Before I go further, I wanted to give a brief introduction about him. He's our keynote speaker and he's an international attorney, mediator, and arbitrator specializing in international dispute resolution, access of trade between China, Israel, and the US. Amit is licensed to practice law in California and Israel and completed his Master of Law degree in Chinese at Tsinghua University of Beijing. Amit served as the vice chair of the China Committee of the American Bar Association and was co-founder and member of the board of directors of the Israeli Chamber of Commerce in China. Prior to establishing Amit and Company International Law Firm, Amit served as a senior counsel at the international law firm Dead Jones, the world's largest law firm. Member of the Israeli Mediation Association, served on the foreign panel of arbiters of China's largest arbitration commission, and was appointed to serve as a mediator for the China Leading Mediation Center, the Shanghai Commercial Mediation Center. Amit is the writer of the international legal column Global Legal Insights, published by the Jerusalem Post. Amit's firm was recognized as one of the leading firms in Israel, specializing in international law and China and East Asia. So over to you, Amit, for your wonderful presentation. Thank you so much.
Hi, everyone. Thank you very much. I'm very happy to be here, and I'm very happy to see people from across the world. I was extremely happy to hear that we have a person from Abu Dhabi, and I'm very happy to hear that. So we're going to talk about international dispute resolutions in IP and talk about a very simple question. Let's take into account that you have a licensing agreement between a company located in California and a company located in Shanghai, and they enter into a very, very simple agreement. That the agreement says that any dispute that they're going to have regarding the license, it can be license of technology, governed pursuant to the laws of the state of California. Very straightforward, very simple agreement. Any dispute will be governed pursuant to the laws of California. The question is, and then what happens is there's a dispute. The California company sues the Shanghai company in Los Angeles, California, as the agreement says. And there's a jury verdict. And when we deal with American law, we need to remember that there's a jury, which is a very different trial method. And the California company wins and receives a verdict for $5 million. Now, the first question is this jury verdict enforceable in China? And I would assume that most of you, a big part, would think that yes, it's enforceable because we have a clear agreement talking about the governing law. But the reality that it's not enforceable, and I'll explain it in a second. That basically it's very difficult in order to enforce a court judgment, a judgment by the court, you need to have a reciprocal arrangement between the countries. That means there has to be or a treaty between China and the United States for enforcement of court judgments, or there has to be a reciprocal arrangement. Both countries recognize the awards of the other country. And the reality is that between China and the United States, there is a big problem enforcing of court judgments. There is no problem to enforce arbitration awards because China and the United States are part of the New York Convention for Recognition and Enforcement of International Arbitration Awards. And that is very important. We're mostly talking from a lot of people are from Asia. And many countries in Asia have difficulty in the enforcement of court judgments, but we don't have difficulties in the enforcement of arbitration awards. So the one keynote first tip of the day is to remember to make sure that your contracts have a valid arbitration clause. And that's something that is very, very important. And it's a very common mistake. And it's amazing how many people, and it's a very common mistake. And it's amazing how many companies fall into that trap, have very lengthy agreements, and they have a simple clause they're referring to governing law, state of New York, governing law, state of Pennsylvania, and remember that they're not going to be able to enforce the award. And of course, it's the other way around. So let's have an arbitration clause. So when we're talking about dispute resolution, we need to remember and to think, what do we really have as an alternatives? One alternative is that the parties will negotiate. And often, I'm now handling a case where we have a dispute between one European company and various different suppliers located in China. And we need to remember and think how we resolve the dispute. One way is to basically refer the case to the company's senior management and to try to see if they're able to resolve the dispute. We're also going to talk about mediation and arbitration and about online dispute resolution. We're going to talk about MedArb, that's a combination of mediation and arbitration, about traditional court litigation, and some tips about American jury trials. The biggest problem is the cost of litigation. Litigation in the United States, in Europe, in North America can be very, very substantial. According to the report of the American Intellectual Property Association, the range of costs for a patent infringement suit that is within the range of $10 million at risk is between $2 to $9 million to litigate the case. That's a huge amount of money. Also, the median cost is for litigation of a patent dispute runs around $4 million. And even in small cases that are under $1 million, we need a very substantial investment of $800. Now, when you look at the United Kingdom, you'll see that actually we have a similar problem. We have basically, we need between £250,000 to £750,000 to handle an IP dispute in this field when we're talking about patents. So we really need to think of different methods of disputes, because the idea of spending so much money is not cost effective and not the most desired solution. One of the heavy reasons why it's so expensive, specifically in the United States, is because we have discovery. I'm not gonna, due to the short time, we're not gonna talk about the discovery, but in essence, it's the stage that each party requests from the other party to show the evidence. And it can be very, very expensive and cumbersome, specifically in the United States. Something called deposition, where each party invites the witnesses of the other party to give testimony, which is done in the office of the other party. It's taking of evidence outside the court system. And it's a very expensive method. And there's an interesting from the former federal chief judge of the Federal Circuit, Randall Radar, that he saw an analysis concluded that only 0.074% of the documents produced actually made their way into trial exhibits. That means we're really spending a lot of time on legalese, legal discovery, searching for evidence, which is not the main issue of dispute between the parties. So another method that we have, if I'm saying not to go to court litigation, is to explore the option of arbitration. So arbitration is, an arbitrator is a person that has a power to issue a binding arbitration award. And that is typically people select an experienced attorney We have in different countries, we have designated arbitration commissions. For example, in China, we have a whole list for arbitration commissions. And if you'll stay tuned, we're going to have a slide that will talk about the major institutions in East Asia regarding dispute resolution. So one of the key benefits when you go to arbitration is you can select your arbitrator and you can look at his background, that he has a specific experience with IP disputes. Is he familiar with trademarks? Does he have a specific education related to technology? Is he an engineer, for example? So you can select your arbitrator, which is a very important thing. You cannot select your judge. Another thing is you can decide the choice of law. You can decide in your arbitration agreement that the law will be handled according to the laws of Singapore, the laws of Hong Kong, the laws of China, or the laws of Israel, or any other country. You can select your language, the place where you're going to resolve the dispute. It can be done in Hong Kong, it can be done in Beijing, it can be done in Bangladesh, and it can be done online. And that's the great benefit of arbitration and mediation. There's also different that allow expedited process in case you need emergency arbitrator. And WIPO has the World Intellectual Property Organization has specific clauses that talk about emergency arbitrators. Usually the final arbitration award is not appealable. That means there's no appeal, and that's a great benefit of arbitration. Some countries allow to have an appeal over an arbitration award, but generally there's no appeal on arbitration award. And the most important thing is that international enforceability of arbitration. Remember, in our first slide, we talked about the issue that court judgment can often be a problem that will not be enforced in another country. On the other hand, the New York Convention deals with the enforceability of arbitration awards, and there are so far 166 countries around the world that recognize arbitration. Next thing that we'll talk about is mediation. As you heard, I'm a mediator in my background and been seeing different international disputes. And coming to the world of mediation was a very amazing opener for me of really an alternative way to resolve disputes in a cost-effective fashion, which is much quicker and really suitable in many cases. And I highly encourage people, if they have any dispute related to cross-border disputes, is to explore mediation by professional mediation, by organization, or by professional mediator, because it will save your client a huge amount of expenses and mischief. For example, you need to remember that one of the key benefits is that the mediation session is confidential. That means everything that is done during the mediation is confidential and cannot be used as evidence outside the setting of the mediation. It is voluntary. That means people can decide if they want to be a part of the mediation proceeding or not, and they can leave at any stage. So nobody is forcing a person to stay in mediation, and if he decides that the mediation process does not fit his current needs, he can leave the mediation proceeding at any time. Another thing is that the mediator has no binding power to make a decision. He's basically a facilitator of the discussion between the parties. And what is the most important is the mediator has the skills and knowledge and experience to really try to find alternative solutions and to verify what are the parties' interests. There's a big change recently due to the Singapore Convention, a recent convention that basically recognizes the enforceability of mediation agreements. So once the parties reach a settlement during the mediation session, this settlement agreement can be enforced. There are numerous countries that signed that signed the Singapore Convention, which is a big turning point in the mediation scene. So I think the most important thing when you have a dispute is of who will be the person that you will select. Who's the attorney that you will select? Will be your warning letters. What will be the approach? Is it going to be a very argumentative letter? Is it going to be an angry letter? Or is it going to be a letter that will invite people and explain to them what are the options to resolve the disputes? And when you look at the image here, we see the American carrier and the Chinese carrier. Remember that even though they have flags, at the end of the day, it's two people that need to do a deal, and they need to resolve their dispute. So I typically recommend in a warning letter, instead of a very frightening letter, "We'll see you in court," we will explain, we will clearly mention that, but we'll also try to lay down people to try to resolve the dispute. One is to elevate the dispute that the CEOs will have a joint session, the CEOs of the joint session, and hopefully we'll talk about the matter before it goes to litigation. Oftentimes the CEO are not fully aware and fully briefed of the facts of the case and the law, and I think that a joint CEO session can be a good start. If they're unable to resolve the dispute, which often happens, then the next stage will be to go to mediation. As I mentioned, it will save huge amount of cost, and even if they don't agree on the matter, they may be able to understand what are their strengths in the case, what are the weaknesses in the case, and maybe even able to agree on different issues to narrow the dispute. To say, okay, 1, 2, 3 will be able to really save them a lot of cost. Oftentimes, even if the mediation does not succeed, they may come later to the mediation agreement. And if we don't have a resolution, then we can refer the case to arbitration, which will really save a lot of cost. I want you to look at the statistics from the UK, and it's similar statistics from around the world, that usually only 3%, 3.5% of claims go to trial, go to a full-blown trial that is determined by a judge or a jury. And if we're able to think ahead before we spend hundreds of thousands of dollars how to resolve the dispute, that'll be a wise way to save cost and inconvenience.
Hi, Amit. Just 1 second. Only 2 minutes to go for the session. So if you can conclude it. Yeah.
Sure. Another thing is to analyze parties' interest. Okay. How to avoid legal fees, to move from litigation to cooperation, to focus on the business, and to avoid the reputational damage to the company. Those are what the mediator does. I have a case study basically that we have, and basically I've been counseling a client which was heavily involved in a licensing arrangement, a licensing dispute, and spent really substantial amount of money. And when he spoke with the guy, he was really not, did not really want the IP rights. He had other things in mind, and really those discussions are something that can be very beneficial. Another thing is to remember the online dispute resolution. It's a big improvement that we have today with the law. And in the same way that we're doing this lecture, we can resolve the dispute online. For example, eBay is able to resolve automatically 60 million cases a year using online dispute resolution. We need to remember about the huge backlog of cases that we have across the world, and why online dispute resolution, arbitration, mediation can be the most effective way. Here we have we have a table summarizing the differences between litigation, arbitration, and mediation. And when you look at it, you see that basically mediation has the biggest alternatives. Mediation and arbitration, and litigation is typically not the most effective thing. If you would like, I'll be more than happy to share the slide, of course, with you. What I would like to talk is to remember about the risks of punitive damages. If we're going to go to court litigation, the court can award substantial amount of damages, up to 3 times in certain cases in the United States related to patent cases, and in China, for example, in trademark cases, up to 5 times. It's not the common thing in China, but there are more and more cases that talk about punitive damages. I would like to draw your attention to the new co-mediation that acted between the Shanghai Commercial Mediation Center and the European Intellectual Property Office. If you have a dispute between a Chinese company and a European company, you can basically refer to mediation, and they will appoint 2 mediators, one from Shanghai and one from Europe. And they'll co-mediate the dispute together, which can be very cost-effective. And also you have mediators from different background and nationality. And usually the time limit is for 60 days. Within 60 days, you're able to resolve the dispute instead of regular traditional litigation that can stay for years. Also, the World WIPO, the World Intellectual Property Organization, has similar mechanisms to resolve disputes in more affordable rates. Those are the key organizations, and I'll close with this slide, which basically shows the different dispute resolution organizations. We have from Shanghai, CTEC, the Hong Kong organization, from Singapore, from Beijing, and I'll be more than happy to hear about the leading arbitration institution in other countries. So thank you for your attention. I'm very hopeful that we'll be in touch. And
thank you, Amit, for the wonderful, interactive presentation, I would say, for the keynote session this lovely morning. So anyone having questions for Amit? So any questions for Amit and his session? If anyone would like to join in on the video. So we have Siddesh. Hi, Siddesh. Do you have any question for Amit?
Yes, I wanted to ask, at the start you said something about that if we have cross-border agreements, there must be some treaty there existing between the 2 countries so that it can be enforced or something like that. So I wanted to get more idea about it, what exactly mean. For example, I am based out of, I am working in a company which has a head office in Singapore, and we have contacts in many countries worldwide. So what precautions I should take for those treaty kind of stuff while executing those contracts?
Okay, that's a very important question. Basically, is to have a proper dispute resolution clause that basically will state how you resolve the dispute. I would typically recommend starting with a mediation organization, and if not, an arbitration commission. In the last slide, I mentioned the different arbitration commissions, is just to have a valid arbitration clause. My input and what I see from the large majority of contracts, most people have only, they're referring to the laws of their own country. And that can be a big, big mistake, because not necessarily it will be enforceable. So have a proper, go to any international attorney that has experience in international dispute resolution and decide on arbitration. It can be, for example, if you're in Singapore, Singapore has the SEIC, it's a Singapore International Arbitration Center, which is reputable. Maybe the other party will want somewhere from another country. Having a valid arbitration clause, very important. And mainly to remember is to have a clause that will state payment of attorney's fees. The huge problem for most people, if they don't have attorney's fees in the agreement, they're not going to be able to afford litigation. If you're going to go to the United States and you don't have an attorney's fees clause, you will not receive reimbursement for your attorney's fees. So it's crucial. Go to an attorney that will look at your dispute resolution clause. It can save you a lot of money down the road. That's basically it.
So much, Sudesh, and I hope that it has clarified. Thanks, Amit, for this interactive session and starting this lovely morning.